Murder, defined. Murder is the unlawful killing of any person which is not parricide or infanticide, provided that any of the following circumstances is present. 1. With treachery, taking advantage of superior strength, with the aid of armed men, or employing means to weaken the defense, or of means or persons to insure or afford impunity. 2. In consideration of a price, reward, or promise. 3. By means of inundation. Elements of murder. 1. That a person was killed. Murder. 2. That the accused killed him. 3. That the killing was attended by any of the qualifying circumstances mentioned in Art. 248. 4. The killing is not parricide or infanticide. Not falling within the provisions of Article 246. Although Art. 248 makes reference only to Art. 246, which defines and penalizes parricide, it is understood that the person killed should not be less than 3 days old, for, otherwise, the crime would be infanticide and penalized by Art. 255. Shall kill another. In murder, the victim must be killed to consummate the crime. If the victim is not killed, it is either attempted or frustrated murder. The offender must have intent to kill to be liable for murder committed by means of fire, or other means enumerated in PAR 3 of Art. 248. Killing a person by means of fire is murder, only when there is actual design to kill on the part of the offender. U.S. v. Burns, 41 Philosophy 418. This ruling is applicable to all the other circumstances enumerated in paragraph number 3 of Art. 248. Rules for the application of the circumstances which qualify the killing to murder. A. That murder will exist with only one of the circumstances described in Art. 248, U.S. v. Labai, 17 Philosophy 240. When more than one of said circumstances are present, the others must be considered as generic aggravating. Thus, when in killing the victim, the commission of the crime is attended by 1. Evident premeditation, 2. Treachery, and 3. Price, reward, or promise, only one of them shall qualify the killing to murder and the other shall be considered as generic aggravating circumstances. See People v. Dueno, 90 SCRA 23, where the rule was applied. B. That when the other circumstances are absorbed or included in one qualifying circumstance, they cannot be considered as generic aggravating. Thus, when there were 10 or more armed captors of the female victim, and one or some of them shot her at the back, the qualifying circumstance of murder is either treachery, abuse of superior strength, or with the aid of armed men, People v. Remelant, 92 Philosophy 48, but if treachery is chosen to qualify the crime, the others are not generic aggravating circumstances, because they are included in the qualifying circumstance of treachery. People v. Sespine, ETAL, 102 Philosophy 199. C. That any of the qualifying circumstances enumerated in Art. 248 must be alleged in the information. U.S. v. Campo, 23 Philosophy 369. Thus, even if during the trial the prosecution proves that the accused killed the deceased with treachery, but treachery is not alleged in the information, treachery cannot qualify the killing to murder, the crime charged being only homicide. It is only a generic aggravating circumstance. The qualifying circumstances of murder, except outraging or scoffing at his person or corpse, are among those defined in art. 14. Except the last qualifying circumstance, that of outraging or scoffing at his person or corpse, those mentioned in the 6 paragraphs of art. 248 are fully discussed under art. 14, which defines all aggravating circumstances in general. With treachery. Treachery, whenever present and alleged in the information, qualifies the killing of the victims is qualified with treachery, when the shooting was sudden and unexpected, and the victims were not in a position to defend themselves. Killing of a child of tender years is murder. The killing of a child is murder even if the manner of attack was not shown. The qualifying circumstance of treachery or alevosía exists in the commission of the crime of murder when an adult person illegally attacks a child of tender years and causes his death. People v. Valerio, 112 SCRA 231. Taking advantage of superior strength. An attack made by a man with a weapon upon a girl which resulted in her death is murder, because the offender had taken advantage of superior strength. His sex and weapon gave him superiority of strength. People v. Quesada, 62 Philosophy 446, People v. Jamer Allen, Gr. Noel 2257, February 19,1950. The armed men must take part in the commission of the crime directly or indirectly, and the accused must avail himself of their aid or rely upon them when the crime is committed. U.S. v. Abagar, 2 Philosophy 417. Employing means to weaken the defense. A person who suddenly throws a cloak over the head of his opponent and while in this situation he kills him. U.S. v. Devila, etal. 3 Philosophy 625, or one who suddenly casts sand or dirt upon the eyes of the victim and then kills him, evidently employs means which weaken the defense. People v. Xiaotong, et al., Gr. Noel 9242, March 29, 1957, 100 Philosophy 1000. The accused, who had direct control of poisoning the rats that might attack the poultry, had in his possession arsenic powder for the purpose. He had illicit relations with a married woman. He and that woman wanted to eliminate her husband so that they could live together. He allowed her to take a quantity of the arsenic powder and put it in the coffee which she gave to her husband. It was shown that the cause of the death of the woman's husband was the poisoned coffee that she had given him. It was held that the paramour was guilty of murder. People v. Bonifacio, 105 Philosophy 1283. Treachery and premeditation are inherent in murder by poison. Treachery and evident premeditation are inherent in murder by means of poison and, as such, they cannot be considered as aggravating. Viada, 3 Cod. Pen. 29. The case of People v. Galura, 16 Ca. Republic 70. To excite a woman sexually, so that he could easily consummate his dastardly lewd desire, the accused gave her chocolate with an overdose of cantharide. Consequently, the woman died, it being a fact that cantharide contains poison. There is no treachery and evident premeditation are inherent in murder by XXX poison in art. 248, and the phrase, with treachery, in the same article. The foregoing distinction should be understood to be the basis of the ruling in U.S. v. Burns, 41 Philosophy 418, and People v. Paterno, 85 Philosophy 722, and the ruling, on the occasion of inundation, shipwreck, etc., of an earthquake, eruption of a volcano, epidemic, or any other public calamity. Killing a person on the occasion of inundation, shipwreck, eruption of a volcano, epidemic, etc., or any other public calamity, when taken advantage of by the offender, qualifies the crime to murder. With evident premeditation. This circumstance is present and it qualifies the killing of a person to murder, when the prosecution proves, 1. The time when the offender determined, conceived, to kill his victim, 2. The word scoffing means to jeer, and implies a showing of irreverence. Illustration of outraging at the corpse of the victim. 1. The act of an accused in having anal intercourse with the woman after killing her is an outrage at her corpse. People v. Butler, 120 SCRA 281. 2. Weighing the victim's bodies with a cement boulder and hubcap and tying their wrists and ankles with nylon cord and wire constitute an outrage on their corpse. People v. Megadatu, 124 SCRA 594. 3. The corpse was outraged when it was dismembered with the cutting off of the head and limbs and the opening up of the body to remove the intestines, lungs, and liver. People v. Carmina, 193 SCRA 429. 4. The mere decapitation of the victim's head constitutes outraging at the corpse of the victim. People v. Weisenhunt, GR number 123819, November 14, 2001. Illustration of scoffing at the dead. The killer scoffed at the dead when the intestines were removed and hung around the neck of the victim's brother as a necklace, and the lungs and liver were facetiously described as pelotan. People v. Carmina, Supra. Penalty for murder. Before the 1987 Constitution abolished the death penalty, the penalty for murder was reclusion temporal in its maximum period to death. With the abolition of the death penalty in the 1987 Constitution, the penalty became reclusion temporal in its maximum period to reclusion perpetua. People v. Guevara, 155 SCRA 327, People v. Lopez, 157 SCRA 304. Republic Act No. 7659 restored the death penalty and increased the penalty for murder to reclusion perpetua to death. In view of RA No. 9346, which prohibited the imposition of the death penalty, the penalty for murder is now reclusion perpetua.